we assess it. I leave that to the side, so I don't want to take that question up. Yeah, right.
But just one additional point about the progressives: their whole critique of the Constitution was unnecessary.
Right. Yes, absolutely.
All
Absolutely.
they had to do was
read the Constitution.
Read the Constitution,
Right.
and they would have had everything that they needed.
Right. In a better version.
In a better version, Hamiltonian version, without these Darwinian excrescences of Woodrow Wilson.
Right. True. Yeah. I say this stuff in here. I do say all that stuff.
Yeah. All right.
And not quite with the excrescences thing.
I added that. Yes. Yeah, I was helping you out. So, yes, Shep.
I'll start.
Professor Malnick.
I look forward to seeing the book because I'm always trying to convince my students they should read the Anti-Federalists carefully and take them seriously as a federal contribution. So it'd be very useful. You start with the assumption on federalism that this is almost a wholly national constitution. The powers of the federal government are unlimited. And clearly, one could make an argument that there leaves that possibility open. But you could make other arguments that there are certainly, it was a government of enumerated powers, and the states were given powers in the Senate, and there were lots of protection, structural protections for the states, and Hamilton and Madison viewed that the states would long have the allegiance to the people. I mean, that was true for the next 100 years. Couldn't you say, Madison said it's a compound republic, not a national republic, so can't you say that the ambiguity was really in the Constitution, not in how it was defended? And one of the points I think you're very strong on is that under the Constitution it's hard to claim you have state sovereignty. But why did this keep coming back? I don't think it was because of anything in the debate, it was because of slavery. So why did this argument keep reappearing is because we were a nation divided, and state sovereignty was necessary to protect slavery.
So it's sort of a yes and no to your answer. The Constitution has all sorts of resources in it, in addition to the resources, say, in the Federalist Papers that can be appropriated, such as equal representation of the states in the Senate, thought to be the great compromise. These were supposed to be examples of states, qua-states, being part of the national government, which was a concern for the Anti-Federalists. Well, and in fact, as you point out, and I talk in the chapter, but not in my remarks, the Federalists make some of the points you made just now. And the Anti-Federalists take the most sophisticated of them up and say, this is crazy. For example, Madison's very sophisticated argument in 39 that develops all the distinctions. This is the compound part: partly federal, partly national, state. You could color code it, blue, green, purple, and the Anti-Federalists have the sense that this sounds good, but how does it actually work? Aren't some of those more important than others, and don't they actually overwhelm the ones so that what's going on there? How does this thing actually work in practice? And what I want to suggest is that the Federalists themselves explain that yes, and defend, yes, they will work in practice to be national over time. So both the Federalists and Anti-Federalists, for example, on the Senate issue, both of them realize, although the Anti-Federalists are much clearer than the Federalists because of the political advantage of being clearer, they thought, and therefore forcing the Anti-Federalists to mute what they know, which is they say this does not do what you say in the Great Compromise. At the beginning, it was true that the legislatures got to pick the senators and until the 17th Amendment, but even with that, they said, these folks are not instructed. They get elected to the Senate, and they can represent the people of those states. They don't have to, or not. They can actually think what's good for public policy. They don't have to actually carry out the will of the states. There's no effective representation of the states, despite the pretense that there is. And so Storing is very, very good on this in a couple of things that he's written, and that's where it came. That's where I get it from. So the answer is yes. There are all sorts of resources in the Constitution that function exactly the way that the early iterations of the Federalist Papers defense function.
Yes, Pat.
Does your thesis have any relevance to the evolution of the Second Amendment debate over the last 40 or 50 years?
You know, I haven't really
State what the Second Amendment is.
The Second Amendment is, well, I'll tell you, it's on my mind because it is on my mind, not in answer to your question. I should have an answer to your question, and I'm not sure I do, but it's on my mind because the Second Amendment is the whole Constitution as far as Texas is concerned currently, and particularly with respect to the University of Texas at Austin, where I am, where as of August next year, guns will be allowed in my classroom, and I may not be able to do anything about it, and we are engaged in bipartisan protest about this currently, so yeah. So the Second, look, I'm not. Sandy Levinson wrote a very good article many years ago called "The Embarrassing Second Amendment." He meant embarrassing to progressives because they ignored it and they would focus on the First Amendment and other amendments as if it didn't exist. And it does exist. And he diminishes in that the way that the conservative current Supreme Court caucus, Scalia and others do, the clause that says with respect to state militias that for the purposes of state militias, people should have the right to bear arms. My own personal view is that clause is very, very important. You know, that yes, the Second Amendment does have a lot to do with the right to revolution and to protecting the states through state militias, but not so much to do with you know, personal safety. But that's a debate that people are having today. A lot of people say I'm wrong on that and everything. But I think that yes, you are right that it's certainly connected to the right to revolution, and there is some sense that revolution would be, you know, inspired by the state revulsion to the overpowering of the national government. So there is I think that would be one of the stronger arguments on not so much federalism, but a concern for the states. Yeah.
Professor Muirhead.
I wondered if you could help me understand better the idea of administration and good administration, which Hamilton invokes as the source of maybe not allegiance, but what will collapse, as you said, the distance between the citizenry and the national government. And I'm curious about what you would say is the difference between an administrative state and just a state or non-administrative state, or if there's a difference between rule in the traditional sense and administration, and what good administration looks like, and also third, your kind of off-the-cuff sense of whether you think Hamilton was right and that good administration has in fact connected the citizenry to the central government, or whether the Anti-Federalists were right and there's kind of there's been an affection deficit that the central government has suffered from.
On the first point, good administration, I think, you know, they refer to it as sort of in its sort of usual sense of administering things in its larger, more capacious sense. And the larger, more capacious sense is the taking off the table the great political questions of alternative regimes, the things that we don't even think about to argue about anymore, which were the subjects of true deliberation. Really, should we be a theocracy, a monarchy, an aristocracy, some things, mixed regime and all that? Should we in fact have a mixed regime so as to continually perpetuate the arguments of those very big alternatives? If that's taken off the table, then arguments come to be about, well, how should we distribute things in a democracy, and how should we make the democracy better, and how should we resolve tensions within democracy? And so, in the largest sense, I think that's what administration means. That, you know, there's the politics, what it means to politically argue, has been significantly narrowed. And then within that, to the extent that you actually do things like distribute resources or to figure out how to do that more fairly and efficiently, those turn out to be ever more technical questions. They're not just technical questions, and that's why they should be debated politically and all that, but there's a technical dimension to them, even when we're not giving them away to bureaucrats. So, and arguing as legislators. Legislators arguing about that stuff, it's a little bit different. So I think all that is meant by administration. Now, on the affection thing, I think that there's a couple things. I think the main thing is that over time it would become clear that the national government was responsible for most things that are important. Now, responsible, though, does not necessarily mean that good administration means that the national government would do everything. And so Tocqueville is actually is the best on this, I think, because Tocqueville is sometimes cited as the great proponent of decentralization. But he actually distinguishes between governmental centralization and administrative centralisation, something like that.
Yes.
And governmental centralization he actually likes. He's not, but he does not like administrative centralization, where the central government not only decides the great questions of how we should distribute things and what the problem is and what needs to be solved, but it actually makes all the little decisions of how to solve it and has intendants down in each district telling you what to do. He doesn't like that. So Tocqueville likes a government that decides important things for everybody, but then decentralizes and delegates, and so in this new complicated nationalist regime, I think the Federalists actually have something of that in mind without expressing it. So the idea is this: over time, for example, on Medicare, or medical care, for example, if we have a national economy, if medical care is a national problem, for all sorts of reasons, it is the responsibility of the national government to confront that problem. However, that doesn't resolve the question of whether is it best confronted with a single-payer system operated from the center. Is it better handled by actually privatizing? Is it better handled by not privatizing but delegating to the states? All those are questions of how to administratively decentralize, and they're all, it seems to me, consistent. They are the administrative debate. Which of those to do? What's taken off the table is that any one of them wins just because of the state's rights or the state's role. The one that has to win wins because the national government has decided that, in fact, that is the most intelligent way to solve this problem, not because we don't have any authority to even talk about it. I don't know if this gets to your...
Yeah, the last thing that's hanging a little bit is, do you think it's an interpretive stretch to say that the kind of distrust and alienation that many citizens, express or feel toward the central government, even today, is a reflection of, some accuracy in the Anti-Federalist diagnosis of its vulnerability?
Yeah, well, I would say it's a combination of two things. It's a combination of two things. One is, I said earlier, to say that an ever-centralizing, nationalizing government is the trajectory of the Constitution, and therefore the best interpretation, broadly speaking, of the Constitution, is not to say that the Constitution is great. So it could get at a pathology of the Constitution itself, a deep pathology that is... The second thing is, so that's one, and I think there's some truth to that. The second thing is, it's been nourished by this anti-federal appropriation of criticism of the inappropriateness of the national government doing things, even when there's palpable evidence on lots of these things that if there has to be some bureaucracy to do it, the national government is a hell of a lot better than most of the state bureaucracies that most people have been, that most people have experienced. And so it's a combination of both. The truth of the anti-federal critique of of this modern new regime, and the power of their claim that this that the Constitution somehow is being violated.
Yes.
I'd like to ask you two questions which I regard as friendly. The first one is,
Watch out.
in your remarks on the convention not really addressing a whole host of larger political science problems, aristocracy, monarchy, etc. In that limitation, that self-limitation, could you not then say that the Constitution still is an amendment to the Confederation, the Articles of Confederation, rather than a whole new start? The failure to go back to fundamentals, as it were, is that this is really not so much a revolution as an enlarged amendment or a set of amendments. And the second question, and this is a puzzle to me, I don't know the answer to this, is there anything amongst the anti-federalists or the federalists which presage the right to nullification, which Madison adopts in the Virginia resolutions, which are certainly an assertion of state sovereignty, real sovereignty within its boundaries?
Good. I mean, both really good. I think that this big issue of taking it isn't that the questions fail to be addressed explicitly. It's this issue of taking off the table monarchy, theocracy. I think you're absolutely right that certainly happens before our Constitution, and maybe even before the Articles of Confederation. So there's no question, for example, that this has got to be some version of democracy or republicanism. Now, the convention actually reintroduces, as part of its deliberations, a little bit of the thing that is foreclosed, because it thinks about, are there ways that we can appropriate from these regimes we're not going to be, qualities that can be grafted on and legitimately thought to be Republican or Democratic. And so there's actually more thinking in the convention of this broader type that I say is not our normal politics anymore than there is afterwards. But I take your point very much that there is an aspect to it that goes back to through the history of modern political theory that isn't just the founders, the Federalists, that they are trading on. And in that sense, yes, it's an amendment in that sense, not a whole revolution. Within respect to the question, the big fundamental question that it's definitely a revolution on is the proposition of whether the central government that is responsible for some very crucial things, such as national security, has a direct and unmediated coercive relation with individuals or not. And that's the revolution. That's the thing that you couldn't just say was an amendment. The second point is really a tough problem. And we actually have to say something about it in the book, because nobody, and I mean nobody, has a very good account of Madison from the point of view of people like me who were schooled at the University of Chicago, who begin always with the proposition that people smarter than you should be presumed to be coherent, intelligent, all the things that go along with being smarter than you. And in the case of Madison, it's very hard to square Madison of not just the convention and the Federalist Papers, but the first Congress of the United States. I didn't talk about here. It's sometimes said that I did in the paper, that the Anti-Federalists won the Bill of Rights. That's true in a sophisticated sense, but in an obvious sense, no, they lost that too, because of Madison's Federalist view that we didn't want what the Anti-Federalists would have wanted as a Bill of Rights. So there's that Madison. And then there's the Madison that you're talking about, the Madison that becomes Jeffersonized. And that is a real puzzle that's now been deepened as a puzzle by a book that just came out that I have not yet read, but am very anxious to, by if anybody's here from BC, a colleague of yours in the BC Law School has written this book with Harvard Press that proves, I'm told, that Madison's notes that were supposed to be, the myth is he went home every night at the convention. He's taking these notes, they're so good. Well, only about a third of them apparently are those, and he revised them supposedly to be published after he was dead in minor ways. No, 2/3 of them are at the urging of Jefferson through the lens of Jeffersonian Republican concerns, and so the whole character and status of the notes of the convention are up for discussion now. Now, what I find, I actually think that helps me a little bit because the convention notes, as we've inherited revised, are actually more nationalist than the Federalist Papers. So if these are the toned down versions through Jefferson's, you got to do something about this, then who knows what they were saying at the convention about what we were getting.
So they weren't as honest as you first thought.
No.
At the convention.
Well, no, when they reported it out, when they reported they were honest. They did say we're going to keep the internal deliberations separated. But when they reported it out, George Washington sends this to the Congress of the United States as an effort to consolidate the Union. He actually uses the word that the Anti-Federalists are going to seize on. And then, as I said, they obviously propose it as a new constitution and violating the rules that they were assigned. So they're honest in all those senses. But they said, yeah, let's keep this secret, what we were talking about. And then Madison publishes this thing, and we all have been studying it for years. And I haven't read her book yet, but people say she combines not just textual analysis, but techniques of reading the documents that can actually show you what were the new, his manuscripts, what were the added pieces, and what were the...
I wonder how honest she is.
Well,
It gives me a moral pain a little bit. Your distinction between honesty over here and rhetoric over here, because rhetoric is mollifying, and mollifying is falsifying, and so if you use rhetoric, you can't be honest.
I think taken as a whole, it is honest. The whole thing is honest. It's an iterated argument.
Yeah.
There are good reasons to iterate arguments that beyond deception.
Iterate means what?
You give a series of versions like that you do maybe in your class because it's hard to understand the complicated one right off the bat.
So that's not dishonest.
It's not dishonest.
All right, I thought.
But it is saying that. But it is strategic. But it is strategic.
Is it ingenuous or disingenuous? Because you use disingenuous rhetoric.
I didn't use the word disingenuous. Disingenuous. Disingenuous?
I distinctly recall it. And anyway,
I did use words like exaggerate, mollify. I did say words like that.
Yeah, but why did you use the word honesty on all this? Because rhetorical, that could be.
I used it in the context of saying how honest the proposal was and how I didn't say dishonest, but how
deprive honesty of the possibility of being persuasive. And so, how can that be? Since all parents, nay, all women would be dishonest according to that definition. People who mollify.
Right.
I mean, and especially if you're teaching, that's not dishonest, or is it?
That's fine. I don't have a problem saying it's not dishonest. I do have. All we're saying is that it has consequences. Yeah. This kind of honesty has consequences beyond the truth of the matter, and so not a whole lot turns on whether you call it honest or dishonest. I don't think.
All right. Yeah. Then don't say it. Right.
I didn't. I said one was honest, but I didn't say the other was dishonest.
Right. Okay. I'll be nice.
You talked about separation of powers at one point. Theory aside, would both sides, if they could come here and comment on what's going on, be concerned about executive overreach, that the executive authority has gone too far? For example, Obama, its edicts on immigration, the recent a treaty with Iran, which is not called a treaty as the justification, which is bypassing Congress. And we now have Congress almost on the sidelines with major political developments with significant policy implications for the foreseeable future. How does that square with what the founders on both sides were trying to accomplish?
My view on that is that what looks that there's a problem that you've seized on an aspect of their projected architecture that does not work the way they projected, but it's normally interpreted as a way you might have thought. I don't know if you think this or not, but that some would gather from what you said as the problem of, say, the imperial presidency. I think if they were to look back at this, it's not the problem of the with a footnote that I'll give in a second, but except for a point, it's not so much the imperial presidency as the imbecilic and abdicating Congress. It's actually a Congress that doesn't work according to the logic. Remember, they thought that this was going to be, a body that drew power into its impetuous vortex, and we had to sort of guard against its assertiveness and its wanting to make too many laws and all that sort of stuff. They did such a good job in sort of building up the executive that it actually works the way that they anticipated, but the Congress does not. And now, it did for a long time. This is a fairly new phenomena, and maybe, Harvey, you'll have me back in a year or two, because I have this other book called Democratic Decay and the Politics of Deference, and it's about this. It's about the abdicating Congress and the change of a culture in Congress, in which the 19th century Congress really did have a robust role in contesting the president. So it, generally speaking, does look like that. Now, there are a few, the footnotes I had was, I think that well, it's not really a footnote. So, for example, the Bush administration and the Obama administration sometimes make claims for unilateral powers of the sort that have sometimes become known as the unitary executive, that these powers are not only powers we have and can exercise, but that it means nobody else can do anything about it. That's not true. In other words, there are contesting powers in Congress that Congress is neglecting to use. Now, on the most recent one that you mentioned, for someone who actually thinks, given on balance, the agreement they came up with for Iran is better than the alternative, I have that sort of political view. I think it's terrible the way the thing played out, and it played out because of a kind of political skill of Obama. He actually persuaded the Congress to think of this as an interpretation of prior agreements and treaties, and therefore to decide to have to disapprove what he was proposing rather than to approve as you would a treaty. So the treaty process was reversed. In other words, they needed a two-third vote for him not to do what he wanted rather than him needing a two-third vote to do what he wanted. Well, he convinced them to make that the rule. In other words, if they had gotten their act together at first and said, look, this is a major consequence to the future of the country, it changes the whole way that we think about foreign affairs, and therefore that's what distinguishes it from an executive agreement to the status of a treaty. We get to decide which one is which, ultimately. And so if you're asking us how to authorize it, that's the way it would have to be authorized. They didn't do that. And so he actually got them caught into the rules that they themselves wrote.
If they had done that, there would have been a fundamental disagreement between congressional perspective and executive perspective. What's the resolution of that? Is that what goes to the Supreme Court?
No, the resolution of that would be other tools that Congress has to use against the executive. He doesn't get other things that he wants. They indicate in multiple ways that he shouldn't be doing what he's doing. Well, for example, if they have if he fails to get a two-thirds vote and does something that he should have done, then they do other things. In the history of Congress, they've censored presidents. Well, what if he keeps doing it after they censor? Well, then you can impeach a president and try them. I have an argument and a view, and have published that impeachment is wrongly thought of as a legalistic thing. It should be thought of as a very high political thing. It's not an ordinary political thing, but it's a high political thing, and its viability makes credible all the other tools that Congress has to contest a president. Because if impeachment is an ultimate possibility, the other things they do are important, because if a president continues to ignore those, they would be the grounds for impeachment. So that's all decay. That's part of this decay story. But this is a decay in the Congress.
What's your definition? Oh, sorry. Okay. Jim Hankins, Professor Hankins.
I kept thinking of the British phrase, too clever by half, when I was listening to your presentation, that there was a lot of disingenuousness, I think is the polite word, in the Federalist case. Starting with the word Federalist, which everyone knew in the 18th century did not mean what was in the Constitution. It's a term that goes back to the Dutch Federation, and people understood that it was decentralized government. But it seems to me that all this disingenuousness and the rhetorical strategy used by the founders to get the thing passed, they ended up shooting themselves in the foot, because they provided the materials for the losers to reinterpret the Constitution the way they preferred. I think, is my understanding correctly what you're saying?
You are.
That there's no way that they the lack of clarity in the Constitution is a result of the rhetorical ploy used to get it passed. So, but my question is really about, and I like this, of course, continues in American politics when the word liberal, for example, was taken over by the progressives, which is done in a very conscious way to conceal what they actually wanted to do. But I wonder if disingenuousness, we should excuse this morally. I have the same reservation Harvey has about this. But my real question is, how do you know if you have? I take it your argument's meant to support the idea of a living constitution.
No.
Well, the idea that there is implicit in the Constitution the subsequent development towards administrative state and towards vast hypertrophy in the powers of defense. I'm putting words in your mouth.
No. You've got me, but the living Constitution part is, living Constitution normally is the idea that people can reinterpret the Constitution to fit the preferences or needs of a given time.
Just using the term, but you're saying there's implicit a much
right.
bigger federal
dynamic
in the Constitution.
Yeah.
But what limits are there on that then? I mean, if you take the general welfare clause, you take national defense, doesn't that implicitly, that could implicitly cover everything?
That's absolutely right. And the limits then are...
So the Constitution offers absolutely no restraint on that?
No, they're political. The restraint is supposed to be political, mainly in the internal organization of the national government itself. Yes, there are supposed to be constraints, and they are structurally induced and political constraints rather than definitional constraints of the
states have no restraint, are not really able to constrain the federal government.
Correct.
In the end.
Correct.
That they're always going to have to bow down.
Yes.
Despite the guarantees of the 10th Amendment, they're always going to have to.
In the Federalist itself, in the Federalist itself, limited government is understood as making a distinction between constitutional law and ordinary law.
Okay.
Do you agree with that, or what?
That I don't disagree with it. So.
That would imply that it's a bad thing to elevate ordinary law to constitutional law, e.g., abortion, same-sex marriage, things like that.
What do you do about the federal government that's not getting the hearts and minds of the populace by all the wonderful things that it's doing for us?
Yeah, that's what Russ was asking about, and I said two aspects to it. One was rather than insist that the growth of the federal government, the growth of the bureaucracy, the expansion of its tasks, all that stuff, rather than insist that that's just inconsistent with the Constitution, one answer is the Constitution could be part of your problem. The Constitution understood as a piece of political architecture, not just a legal set of things. By the way, as I point out in the paper, Madison makes this point about mere parchment distinctions not being enough. The Anti-Federalists realized that that's all that was offered with respect to federalism. So it's obviously not enough there. And then the second thing, as I said to Russ, is that, so one is the Constitution itself, and the other is the sense that if people have an understanding of the Constitution that seems to be violated because you have the anti-federal interpretation of it, then you can develop a cynicism to the excesses of national power on that basis. So those two things come together to reinforce this cynicism.
I'm just trying to get at what you're recommending. So you're recommending that people don't take refuge in constitutional interpretation. There should be a straight political fight. And people should say this is good for the country and this is bad for the country, and not this is constitutional, this is unconstitutional. Would that be reasonable?
One. Number two, I would say that if you really think that some of the things that you think are just usurpations are bad, you ought to think about whether you've got a broader constitutional problem, not just a usurpation. Right. So I don't mean to dismiss the concern. I just mean to dismiss the way that the concern is argued. So I think it makes a huge difference, for example, whether you say we don't need to have a debate over some important issue because that's just left for the states, as opposed to saying, no, it really is an important issue. We do need to debate it, but the best resolution, the best practical resolution would be to delegate it to the states, or would it be to leave it? That's a hugely different thing.
Yeah, I'm with you there.
Yeah.
All right.
So I guess there's two general objections I wanted to raise. I'm trying to prevent me to know if I've understood your thesis from getting on board. The first is that it occurs to me that your critique of certain ways of thinking about the Constitution, it seems reminiscent to me of a critique of a kind of legal formalism that's offered in general in critiquing a kind of liberal rights regime of any kind. That rights talk ascribes a kind of principled beginning position, or at any rate, and that if you peel back or look squarely at the situation, there's always a political battle going on behind all this rights talk. That seems sort of reminiscent of what you're presenting for the Constitution as political architecture. But I mean, for me, the bigger difficulty would also be that if you look at, say, Tocqueville, there seems to be the hypothesis or concern that democracy as a social phenomenon or a social state is so powerful as not to be likely to be restrained by any constitutional forms. That seems to be the dilemma. And so his treatment of, say, the American founding stresses much more the Protestant Puritan founding, and other events, rather than the Constitutional Convention and the Federalist. And I guess the difficulty I have is that if you say, well, the Constitution's significance is in this political architecture that's set up, which sets up a battle and has various results, and one result is the extraordinary increase in power of the federal government, the bureaucracy, etc., none of which is in principle unconstitutional, and therefore...
No, the last part I don't quite go with. So it means that you have different kinds of constitutional arguments, not that you don't have any. So if you mean the analogy to the critique of legal formalists that say, it's just politics, meaning whatever happens, and that's the law, as opposed to any way to judge or to assess. That I do disagree with. It's more a different way of thinking. And the best example I can give you is former undergraduate student of mine who went on to grad school elsewhere at Princeton has written this very important new book on war powers. Mariah Zeisberg won a bunch of awards and stuff. And what's important about it is she says, look, there are claims of the executive and the legislature in America over war that conflict with each other. That is the way it's supposed to be. That is part of the political architecture. That doesn't mean that citizens viewing these claims have to just not have any way of saying, you know, whether they're right or not. It does mean that courts can't legalistically determine these boundaries because of certain political dimensions. But one can abstract from these political dimensions a series of standards which she seeks to do that can inform the debate over the exercise of these powers, to be able to say, and I won't go into her particular argument, that can able to say, no, that's not right, even though it isn't the kind of legalistic argument that we're normally familiar with. So there's a position that isn't just it's whatever comes out politically, or a judge parses and comes out. There's something in between that that acknowledges that acknowledges the fact that that there are legitimate contending perspectives on the same political problems, and that we want to make a virtue of those contentions in our political architecture. So it's not just checking and balancing.
But on the other
Josh,
hand,
Yeah.
I'd like to make what I hope is another friendly observation. It is only semi-scholarly, and I'm a weak Latinist, but I'd like to say that I think you might want to explore the meaning of federal in America and in Europe in the 18th century. Let me go back this way. The Latin root, one of the meanings is treaties, alliances. And here you have alliances not through a monarch. There are those who would want to call the Holy Roman Empire a federation, but directly with each other. So you have united provinces with regard to the Netherlands in their constitution. And it seems to me that the question is, what is federal? For example, les fédérés during the French Revolution are the decentralizers, mostly from the Southwest. And so there's a question of understanding what this alliance is. In other words, the federal gets us hung up on contemporary meanings. And it seems to me that to understand more fully what that is makes this switch that you see less peculiar, less surprising, but actually a struggle to understand the nature of a federation. And that's why I raised my bewilderment at Madison and nullification, that the grasping of what federation means to these people is important for your thesis.
Yeah, and I think in support of that, and also piggybacking on the early question about Madison, is one answer to the Madison puzzle is that while Hamilton and others realized that the middle iterations were steps on the way to the most truthful argument, not dishonest, but steps on the way, that Madison actually thought that stuff. And so when we went farther, he became an heir to himself, you might say, and tried to resurrect those middle iterations. That would make him more consistent. Michael Zuckert makes an argument. He doesn't make it like this because he doesn't see the iterations, but he makes an argument that basically Madison is consistent because Zuckert finds these arguments that Madison makes that I think are incomplete, and that the Anti-Federalists rightfully show are incomplete. He thinks that they're fine, they're complete. And if you think that, then it all works together. Yeah.
Part of the debate here seems to be between your defense of a Hamiltonian Constitution and other people saying, well, the Constitution is not that Hamiltonian. And in response to your question to Russ, so basically we have, we have a indicate, we have this very large federal administrative state in which the federal government runs all of these things. I just think that that's empirically incorrect.
That wasn't my response.
I just want to say that part of what's true is, the states play an enormous role. The federal government doesn't administer all that many things directly. Almost all of these things are administered through the states. So the states still have this huge role, and say that the federal government has this very powerful bureaucracy. I just think it's in important ways incorrect.
Right.
So
I didn't say what you said.
misinterpreted you.
I didn't say what you said. The question is whether they do that at the sufferance of the national government, not whether they do it or whether they do it at their own insistence. I do think that there is a residue of a problem for the states of this nationalizing tendency, which is the other side of your coin, which is not only can the national government either be pleased that the states are taking on problems that are of national scope and administering for them, or even fund them and ask them to do it. But in addition to that, you have unfunded mandates, as you know, and that is, it seems to me, a serious problem, but is actually born of the nationalization of politics. It's this kind of perverse thing where, yeah, we're responsible and we're going to tell you you're responsible and have to make up the money. So it's sort of a poor use of governmental centralization for the purposes of administrative decentralization.
Yes.
I find really interesting your description of Hamilton's sort of three-stage argument of, if I understood it, first stage was, well, we're going to have a more sort of centralized entity, but the powers will be limited. Well, stage two, it's hard to limit powers, but the purposes will be limited. Stage three, well, it's hard to limit purposes, and what exactly would that mean? So I was wondering if you could elaborate on that third stage, in terms of what Hamilton had in mind, how, because I'm not familiar with the arguments that he makes, how broad he might have conceived the purposes. If, for example, you see that third stage as opening the door towards what you earlier called the refounding, and then maybe something like the New Deal, I'm assuming Hamilton would have problems with those later developments. But
yeah, I don't think he would. Would be my view. He might have problems, as Harvey suggested, with some of the kinds of arguments that were used to justify things. But, for example, when Eisenhower, a Republican, makes an argument for national highways for defense purposes and as well as commerce, that's like, Hamilton. When Eisenhower, a Republican again, under the New Deal regime, makes an argument that we really need to beef up education across the country in mathematics because the Russians are going nuts, and we somehow have to catch up for national security reasons because the education of the country is somehow attached to our security. That's exactly whether that's a good argument at the time. It's the kind of argument that Hamilton is actually speaking to. And so, yeah, so you can see that when you think through national security, and when you also think, and I think that they really had a more robust understanding of general welfare than is often talked about today. There's a new book coming out. Sandy Levinson and I edited a series at Kansas called Constitutional Thinking, and there's a book coming out next month by Clement Fadovic on founders and the whole issue of inequality, the issue of today, and suggesting that they had that they were much more concerned with it than you would think from today, because they saw this issue of relative economic equality as connected to the notion of political freedom, not just of individuals, but of a free people. And so anyway, develops this to suggest that there was really a lot of concern in principle with things that we later came to think of as new. So yeah, I think that Hamilton would be very understanding of the trajectory of American politics, though he would take issue with some of the defenses of it. But yeah.
Alex.
I guess since you brought up the living Constitution, I wanted to press you a little bit on that. I mean, what is the relationship between that view and yours. In the way you presented the expanding government is, I guess, implicit to some degree in the founding. Of course, there's certain aspects of it that are based on, for example, technologies that probably didn't enter Madison or anyone else's head at that time. So there's always an element of it that has to do with historical change. I mean, similarly with moral doctrines like abortion and gay rights, those weren't rights that entered the head of any of the founders. So you have this fact of historical change, and does your view, cover or provide an explanation for how to respond to historical change, or is there an element of historical change which simply requires, prudent responses which aren't found in the original Constitution?
So there's a lot in there, and so let me just say, the first point I want to make is that the legalistic, narrow understanding of constitutional meaning suggests that constitutions are either some sort of settlement or legalistic document whose understanding is tethered to the extant practices and understandings of the time in which it was written. The problem with that is that it simply does not square with the project of building a regime and building a piece of political architecture, which is not a settlement for the time. It's an attempt to create a future. Point one. Second point, some people think that a constitution is limited to the specification of offices and powers or the governmental entities or something like that. Constitution makers think, if they're thinking broadly, that it's the making of a whole regime, not just offices and powers, a whole regime. That's why large parts of the Federalist Papers, which we think are the most thoughtful of the reflection on this Constitution, don't mention any clauses of the Constitution, like Federalist 10, a big classic. It's not about parsing clauses, and it's actually reflecting on the character of the culture, the society, and the economy that would be induced or implied by what decisions are being taken. So a constitution, in this sense, is a forward-looking project, and it does suggest a projectable future, and the Anti-Federalists and Federalists share that understanding. Now, I don't mean to suggest, once you understand that you can therefore say that anything that happens subsequently in American history is somehow consistent with the Constitution. You have to have an account of why the commitments that were taken then imply these developments or imply these understandings or imply these principles. And finally, I would say that the appeal to me, and I do say this in the paper, and this is following Storing, who was my teacher, the appeal to me of Hamilton and Madison to some degree and some of these founders is not that they were there. It's not that, that we should worship them. It's not that they're authoritative because they were in the room. It's that they were smart, that they could see the meaning of what was being decided by everybody else, even if others around did not see that. Now, if you adopt that perspective, the meaning of the Constitution inheres in the decisions being taken, and observers can analyze those decisions, and in principle, anybody could do that. Now, they have advantages. Being smarter, being there, seeing are advantages. But in principle, somebody today could have a better understanding of the original meaning of the Constitution than Hamilton or Madison, in principle.
Well, thanks very much.
All right.
This is wonderful.